Good afternoon. I hope everybody is with us. Please, can someone just wave or say hello so I can see if you can hear or see us? Yes, great. Okay, I see that we are on live. Okay, so good afternoon. Thank you for joining us on this Simply Biz chat about retrenchment. Not a very nice topic, but it is one, unfortunately, that with where we're at today, it is quite necessary. Hopefully, we can help you through what is a really tough time. My name's Jan Askew. I have a human resources and small business background, and you'll see on the other screen there is Leigh Allardyce from Allardyce and Partners, and she is a natural labour lawyer. So although we both went to law school together, she went the pucker route and I went the light route. Okay, but we're going to try and keep this very informal, very practical. So please do feel free to ask questions, pop your questions in the question section or in the chat, whichever works for you. We will be checking in between both. But otherwise, we're going to get started now and we'll be moving forward. Okay, so let's just make sure this works. There we go. So we've spoken about this being a DIY toolkit, a retrenchment toolkit. And when Leigh and I were planning this session, we said, you know, so many people are completely overwhelmed. If you're in the situation where, as a business owner, you are having to start downsizing and retrenching staff, you're in a bad space to begin with. And now you're faced with this legal quagmire, and you must feel like you're tiptoeing through a landmine infested area with crocodiles and all sorts of threats. So we thought, most people don't know much about the law, and in fact, most people are terrified of the law. And yet, ironically, the law is there to help you, and it's also there to help your employees. It is there to make what is a really awful process a little bit more straightforward for everybody, and obviously, as far as possible, fair for everybody. So we are going to be talking about the law, and we're also going to be talking about some of the legal, obviously the legal concepts, but the human aspects as well of retrenchment and how that might impact your business and how you can manage this process a little bit simpler for yourself. We are very much talking to businesses who've got less than 50 employees. That was an assumption we made with this being a small business seminar. Those of you who might be slightly larger and have more employees, you will fall under Section 189A of the Labour Relations Act. That is more complicated. It's similar, but there are more rules and regulations. So you do need to be aware of where you fall in terms of the Act. And I do urge you then to contact Leigh from Allardyce and Partners, because it is much easier to make mistakes in Section 189A than it is for a straightforward Section 189, which is for under 50 employees. The BCEA, or the Basic Conditions of Employment Act, also governs retrenchment in this country. And in fact, we are, as South Africa, we are a highly regulated country, highly regulated when it comes to labour law. The pendulum has swung over the years from being very pro-labour to being very pro-employer and then back again. Unfortunately, from a small business perspective, the current laws as they stand are rather onerous on a small business. Small businesses are expected to pretty much follow exactly the same requirements as a large multinational corporation almost. So it is harder on a smaller business. But by following what we're covering in this webinar and downloading the tools that we will show you at the end from the Simply Biz website, hopefully you will be able to navigate this without too much trepidation. And we will try and demystify some of the terms and some of those things that we're all a little bit more scared to do as we go forward. Okay.
Thank you very much for giving me this opportunity of joining you, Jan. And just to reiterate, Jan is right. Please, guys, we can't emphasize enough that you need to comply with the requirements of the Act. The Act says out very clearly what you are required to do. It's almost a step by step. And this is also why we call this the DIY approach to retrenchment. So there are a couple of pitfalls, and one of the pitfalls is knowing who to consult with. But the first part of your retrenchment process is you have to consider what is the applicable and governing laws and contracts. Jan has dealt with the laws itself, but you need to have a look at your contract, because your contract of employment, whether it is the individual or whether there is a collective contract, which we call collective agreement, and sometimes that goes even further, it's broader than that. It's your main agreements, which are concluded between you, the bargaining council, employers' organizations at large, as well as the unions at large. So the reason why you need to consider these is for example, what is the notice period that you need to pay? What is the amount of severance you need to pay? If those contracts are silent, you would then obviously default back to the BCEA. And if not, obviously the contracts and or any policies that the companies are governed by will be applicable. So please, before you even begin your retrenchment process, know exactly what your contracts are that govern the relationship itself, the employment relationship. Now, a little bit, taking it a bit further, another pitfall is exactly who do you consult with? Now, the Section 1893 sets out very clearly what you are required to consult on. However, you are required to give your employees a written notice which sets out all of these requirements so that the employees are fully informed as to exactly what to expect. Now, as Jan said, it's there to help both the employer and the employee. This notice will set out the requirements as are set out in Section 189, as well as Section 189, subsection 3. Who do you give that notice to? And this is something that many people make a mistake with, because if it is just an individual employee, you would give the notice just to that individual employee. However, if there are unions, and, as I said, the collective agreements and bargaining councils that are involved in respect of the collective and the main agreement, it is vitally important that the notice goes to the unions as well. And in fact, as a general rule, we actually give notice to all the parties to make sure that no one falls through the net. Because sometimes, for example, your managers may not be a member of the union, and you may have forgotten that fact when you give notice. So when do you give this notice? It is very important for you to give the notice as soon as retrenchments may be contemplated. In other words, this COVID lockdown period has caused many people to have to review, reconsider, and restructure their organizations. That in itself falls within the ambit of the Section 189. In other words, you should in effect be giving notice to your employees that you may need to restructure. In other words, your operational requirements are such that you cannot continue going in the manner that you are going now. You need to take positive steps in order to ensure the sustainability and viability of your business. And my suggestion is, if this is your case, give notice. Don't feel frightened to give the notice because people may think they are being retrenched, or they will definitely be retrenched. We're going to unpack it a little bit more, but allow your employees to know what's going on. Be transparent, communicate. The more you communicate, the less likely you are to have misunderstanding, miscommunication, and very low morale amongst your employees because they know what is going on.
So, Leigh, if I can just pop in there, it was interesting because the slide was showing all the different technologies that are available today, all of them being remote. And when we think of a written notice, we tend to think of a formal legal document that has been served on someone by a member or a sheriff of the court. And the interesting thing is that over time, that has actually, the things have started to change, and the courts are definitely looking more acceptably at technology. But the one thing that you really surprised me when you said that there's been such a development with WhatsApp, and maybe you want to share something along those lines.
Thank you, Jen. Yeah, in fact, during the lockdown period itself, the majority of and I'm going to say the contemplation of the retrenchments was done via WhatsApp. Now you can even terminate via WhatsApp. So a lot of organizations have communicated only via WhatsApp because their employees haven't had access to any of the video conferencing type platforms. So all the consultations may be done telephonically, recorded, obviously minuted, and the minutes are then sent to the employees by WhatsApp. One of the important factors to bear in mind is that you need a record of what's going on, because you may not retrench today, you may only restructure today, or you may take steps to avoid retrenchment, but retrenchment may become a necessary evil at the end of the day. So you need to have a record. And it's also very important. In fact, I'm finding now in practice that the majority of cases, whether it be misconduct or retrenchment or whatever, most of the evidence is produced via WhatsApp messages between the parties. So, any form of recordal but is sufficient. But more importantly, the written recordal, such as WhatsApp, SMSs, emails. Some employees don't have access to those. So whatever you've got access to, and you can record it in writing, you need to do so.
Yeah. I think that's actually very important, that as you go through this whole process, you will see that there are certain things you absolutely have to do as an employer retrenching an employee. But the main thing that every lawyer and every human resource person, believe me, says all along is build your evidence file. Okay, show that you did stick to the letter of the law. And we'll be talking a little bit more about fairness just now, but you need to be able to show anyone, if you are ever questioned, this is what I did. Here's my evidence that I did actually follow the letter of the law to the T. So the more evidence you have, and obviously be it electronic or be it actually in writing, is obviously the part of that documentary evidence and that documentary proof that you actually did do what you were required to do. And I think particularly, I'm stepping a little bit aside from our topic here, but it's the same with disciplinary inquiries and performance management. It's anything that you do with employees. The more you can prove your side of the story, then it obviously helps to build your case, whichever. And hopefully, I'm sounding like we're very antagonistic, but it's not. You just need to be able to show that you have actually covered all the bases that were required of you.
Jen, quite so. And, it's not antagonistic.
No.
It actually helps both parties. I often act primarily for the employees, and they're the ones that produce this as evidence. So it's easier for you to know. It's easier not to make mistakes.
Yes.
If it's writing. So, it's protecting you. It's protecting the other parties. So, yes, it is required by law, but it's your protection.
It is.
If we take it a little bit further, the actual notice, I dealt with this very, very fleetingly just now about who do you give the notice to. We are addressing primarily those employers who have less than 50 employees. If there's no union, who do you give that notice to? Some employers prefer to do it collectively, where they will actually ask the employees to nominate a particular representative, or if there's a current workplace forum, it's someone who can represent the needs and the representations of the individual employees. If it is the individual employee, him or herself, often that person would nominate someone else. There's a great debate that goes on, and we don't have time for it. The legal argument is regarding, can an attorney be the nominated legal representative? And that is an argument for another day. But my suggestion is that you make sure that you communicate with your employees and their union and or their nominated representative. And if it is the workplace forum, it makes it more difficult sometimes to prove that that person is in fact the nominated representative. So my suggestion is ask the employees to reduce that to writing. And that way you can't be faulted when you are communicating or giving notices to this nominated representative.
Yeah. Leigh, I think also what we might need to just cover here is the whole issue of language. Obviously, in South Africa, English is the business language. It's the most accepted in business. But you've also got to be real. If you've got mainly employees who are speaking, excuse my language, Xhosa or Zulu or whatever the language may be, giving a letter in English is perhaps not very helpful and could actually lead to you being undone, because then has that person actually received notice? What's your feeling on that, Leigh?
From a practical point of view, there's no legal requirement. Your legal requirement obviously is in English, but from a practical point of view, I will ensure that we get an interpreter for the language that the employee or employees speak. So quite rightly, you can't restrict it to Xhosa or Zulu, or Afrikaans is another one. So rather get the interpreters for the different languages if you believe that there may be some form of miscommunication or misunderstanding, or you want to make sure that the employees feel more comfortable during the process. So we do it as a matter of course. And if you go to the CCMA, let's just say for argument's sake, you have more than 50 employees, you would then have that process facilitated. You could do with the CCMA. And the nice thing there is those interpreters are available free of charge at the CCMA to assist in interpreting the proceedings as well as what has been said. So from a practical point of view, I would recommend it. There have been times when, for example, you have Mozambican employees who speak Portuguese. And it makes it more difficult, especially if it's a facilitated process, because they are not always accredited Portuguese interpreters. But if you can, please try and do so, because then your employees are being treated fairly. They understand the process.
Yeah, and understanding is the key. It really is, because this has got to be an engagement. It can't just be a one-way street. And I think this goes really to the heart of labour law, in fact, law in general. The whole thing, you've got to be fair and you've got to be seen to be fair. So the 100%. Seen to be fair is the procedural, the tick box side of things. Have I done all of the above that's required of me? But then there's actual fairness. There are many elements that come into that, but I think language is a key one of them.
100%.
Yeah, thank you. Okay, so we were talking about this difference between procedural and substantive, and basically, I'm going to quote my labour law lecturer from way back when, and he basically said that if you fail to follow the procedures that have been set down in law, I mean that there is no escaping this. These are the rules of the game. If you fail to just follow the steps as an employer, you may as well score a home goal. Okay, it is such a waste of energy, time, effort, and it's so unnecessary. I'm not trying to pretend that, people don't go to the CCMA on flimsy reasons. They do. But most of the time, if you have actually followed the rules, if you have done what is required, and if you can look yourself in the mirror and you know that you actually did try everything you could to avoid retrenchment, most of the time the courts will agree with you. But don't give away any kind of process advantage by just not following the laws. And the wonderful thing about the Labour Relations Act and the Basic Conditions of Employment Act is that it is all stipulated there. So these points that we've got up on the slide are taken directly from the acts. This is nothing that's not known out there. So the law does try to make it as straightforward for both parties as possible, so you both know what to expect in the process. And it keeps you on the straight and narrow, which is always a good thing for employers. So the one thing that you really do need to consider is the reasons for the proposed dismissal. We've both alluded to the fact that this has to be a last resort. You cannot jump straight into retrenchment. And ironically, given the times that we're in right now, a pandemic, lockdown, and all of the attendant problems and challenges that these have brought around for businesses, you can't just simply say COVID as a reason for this retrenchment. It seems so self-evident, and anyone with half a brain would agree with you. But the law is saying we need more. We need you to show that it was indeed so devastating on your business that you have been left with no alternative. So you really do need to show that you have considered, and considered genuinely, any alternatives, be it part-time, be it flexi time, be it reductions in salaries, whatever, but that you have tried to avoid this at all costs, because it really has got to be, I've got my back to the wall as an employer. I do not see any other way that I can save my business unless I start cutting costs significantly. And usually we do all know that that means a labor cost cutting of some sort or another. So how do you show that? Well, it's quite straightforward. A lot of the time, what are your financials saying to you? If you can show an absolute nosedive in sales or in revenue, that's also feeding into the story, because you are building a story here for a potential third party to look at the case and say, absolutely, we understand this business is in financial trouble. You can show the history that year on year or month on month, what has happened from one scenario to the next. You can maybe show what you've done in terms of other cost-cutting things that you've implemented. You might have really tried to go efficient and super lean and mean in every other way. All of that, as long as you have got the evidence, you can show that I've tried everything else and I am now at this point where I have to retrench. So it really has got to be that you've considered it, and you can show that you've considered it. And employees are not stupid. I'm not in the least bit trying to say that nobody is entitled to make a profit out of business. But if you've been taking tons of money out of the business and then suddenly say that you don't have money, I don't know. Leigh, would you like to comment on that in terms of the management issue there?
It is correct that there are cases where mismanagement itself has been held not necessarily to be the reason, or that the employer can rely on as a reason for retrenchment. They are far and few between, and it's quite difficult for an employee to prove, because he said, she said is not sufficient. You would need positive proof. But I think that at the moment, and this is the need that is the greatest, is as a consequence of what the pandemic has done to our economy. Generally, the need may arise due to the economy itself, your financials, but there is another need or reason that has arisen with remote working conditions.
Yes.
How many organizations have found that restructuring, allowing their employees to work remotely, works better for them. In fact, many have found that it is far more productive. And as a result, they are restructuring and, in cases, retrenching, not necessarily based only on the financial aspect. They are restructuring, retrenching based on the fact that they don't need as many employees as they did before. Or, for example, a lot of organizations are giving up their big overheads. So it's not necessarily a retrenchment that they're trying to cut the costs. They may actually no longer need so many employees because they don't need a 12-story building anymore. They only need 4 stories, for example. Yes. So what you were saying earlier is the reason must be real and it must be fair to everybody. So it's not just that the employer finds I've had enough or I'm enjoying the employees working remotely. You've got to establish why that is good for the business's operational needs. And that is why you're embarking on this process.
I think that's such an important point you brought up, because there has been such a leapfrog in technology and remote working. The 4th industrial revolution is on everybody's lips, just like the word pivoting at the moment. And a lot of businesses are responding quite well to it. The thing is, and this is where the challenge for the employer comes in, if you are now in a situation where you have changed your business, you have shifted, you've pivoted because now you need to go in a particular direction, which was perhaps a very different plan 6 months ago because of technology and because of the need for remote space, social distancing. Now suddenly you might have a situation where your staff can't keep up. They do not have those skills. So it is a tricky one to manage, because at the same time, the courts don't like us just willy-nilly retrenching. But as long as we can show a complete business need, that I need these skills, I no longer need those skills. And it's not actually, it's the business. Yes. I think that is the key. So it's always a strange one, because courts shouldn't really be getting involved in operational issues. That is the realm of business, and it is the realm of the decision of the decision maker within the business. But it is always back to that issue of what is fair and who determines that. And I think the mythical reasonable man will always come in there, as you know. Anyone who's married knows it's a myth. But yes, can someone see the reason? Sorry.
No, I was just going to say that the court sits as an arbiter where an employee generally doesn't have that power. So they don't, as a general rule, like to intervene in the employer's, what we call the managerial prerogative. But where it is patently unfair or groundless, in other words, there's no substantive reason, or the substantiveness is not fair, then they will intervene.
Yeah. Thank you. So I'm not going to sort of labor through these points, but I do just want to highlight the issue of criteria, because that's also a very important one. And Leigh, in the next slide, will be unpacking the actual notice and what you really do need to pay attention to. Every single one of these steps you have to do as a person retrenching. But there's reasoning behind it, and it is not a checklist. Although it looks like it is a checklist, the courts really do require an application of mind, and it has to be a fair application of mind. Are you open to alternatives? So when it comes to the criteria, this is perhaps the most important. This is not a performance management situation. This is not your chance to get rid of that little bit of deadwood who always sat in the corner and didn't really produce too much. Most small business owners who've employed a number of staff will always have one. And it may be very, very tempting to use this opportunity. You're in a crisis, and to say it's time to get rid of that one. The moment you do that, it becomes very obvious, and you are leading yourself into a challenge in the CCMA or in the labour law court. It's not the format, it's not fair, it's not right. This is not the time to be going after performance. This is purely about operational needs and the fact that the business needs to get, needs to reduce staff, or it needs different technologies, whatever it might be. So the criteria could just be as simple as LIFO, last in, first out, which is the most commonly used. These days, the courts are a little bit more aware of nuances, and so you can say it will be a combination of LIFO, and it might be that we will also look at technological skills that are required, or the level of education that is required, language skills, whatever it might be. But they need to be applied across the board. This has got to be an objective test. It cannot be, I like Sue, but I don't like Solly. That is not the way we can do that. But I'm going to hand over now to Leigh, who's going to take you through some of the deeper aspects of the notice.
Jan, just going back one slide, you raised a very important point about the participation. The Act specifically provides that this is a joint consensus-seeking exercise. In other words, both parties need to apply their minds. Both parties need to participate in the process in order that where you can avoid the retrenchments. So there's an equal obligation on an employee to come to the party and say, well, your criteria of LIFO is not good. For example, you touched on the technological aspects. What if a person has only been there, and a lot of our younger generation are far more technologically advanced and equipped to deal with the fourth industrial revolution, as you rightly pointed out. So they may have only come in today, and somebody else may have been in the same position for 35 years or longer, but he or she cannot adapt to that. So when looking at the criteria, LIFO is not the be-all and end-all. And I'm raising this because I had it this week where an employee approached me, and his rationale for going to the CCMA, which, by the way, was in the wrong forum, was that the company did not use LIFO. Well, you're quite right. LIFO is only one of the indicators, not the criteria to rely on.
And it's quite a blunt instrument.
Yes, quite. And a lot of people now, because of the change of needs, are in fact doing gap analysis, skills gap analysis. They're reevaluating their technology, their structural requirements, etc., because the advances have happened so quickly in South Africa, albeit that for a number of years this has been a worldwide trend. We are a bit behind, but with COVID, we've had to move very quickly with the times.
Absolutely.
Some of the other things that I just wanted to touch on when we are unpacking of the notice, so I'm flicking between the two slides, is that what is the actual severance? How much do you pay the employee for the severance? Now, if the contract or the collective agreement or the main agreement or any policy that a company has is silent, it defaults to the Basic Conditions of Employment Act, which provides that it is 1 week for every completed year. Now, your severance pay is not something that an employee or an employer thinks that he's being kind and nice and is actually mitigating the adverse effects of retrenchment. It is statutorily governed. In other words, you have to pay it. It's the minimum you pay. So you would pay, if the person was to be retrenched, the notice pay, whatever it is in terms of the contract, or once again, default back to the BCEA, plus any outstanding accrued leave, plus the severance pay. That is your minimum that you pay your employee. There is no question about whether or not you negotiate on it. I had a client today who asked me, could he wants to get them to agree to a lesser amount. No, you cannot make an employee waive his rights to his protections under the LRA, and you cannot make him accept a lesser package because it suits you to do so. These are monies or amounts that are statutorily governed. It's your minimum amounts. Sorry, I just thought it was very important after having heard that today. The other aspect that you would put in the notice, and that's important, is the likely date for dismissal to take effect. Well, at the moment, it's almost up in the air for a lot of companies, because a lot of companies have been very proactive. They've taken the steps to try and avoid the retrenchments, and with those steps to try and avoid retrenchments, the likely date of the dismissal has actually moved. Sometimes it's been moved out by 6 months. Sometimes within the 6 months, the date has had to be reconsidered and brought forward. So please just keep communicating with your employees, because bearing in mind, the retrenchment is the last resort. So you're going to do everything in your power to try and avoid the retrenchments. But the communication is the key. What about the assistance offered? The same client today, the assistance that he offered was the UI-19 form and the certificate of service. It's not sufficient. Those are statutorily required. You've got to give it to the employee. What they're talking about is what assistance. For example, and I think, Jan, this is where your forte would be, is how do you help that employee to become self-employed or to survive when he's left the employment? I don't know. I'm sure you're going to unpack it a little bit more. But it most certainly is not the bare necessities that the law says you must give.
No, as you say, they are the bare necessities.
Yes. I think that the one thing that we say, that the mitigation, the onus is on you. There's actually an onus on both parties to participate, because quite strangely, a number of employees recently that I've come across have come up with the most unique and creative alternatives to their retrenchment. And it's impressed me, because, for example, the one designer actually came up with a suggestion that within his employment, during his temporary layoff, for want of a better word, that the company assist him in setting up his own design company as a graphic art designer. And he would then consult to them during this period, subject to a very clearly defined retainer after the 6-month period. So he's allowing the employer to be able to, during this period, not have to pay him. Subject to 6 months later, there's a contract in place. So it's just something to bear in mind when looking at it.
So the interesting thing is, I think obviously the employee is encouraged to put forward alternatives, and I think a lot of people are being quite creative about how they can actually work with the employer. At the end of the day, though, is the onus not really actually on the employer? He has to show that he or she has listened to the employee, has taken these suggestions into account, and has actually either accepted or rejected or part accepted them. Is that not the case?
100%, because remember that it would be an employee will accuse an employer of unfairly retrenching him.
Yeah.
So quite rightly, you've indicated a little earlier that the balance of probabilities, who bears that onus? The employer has to show on a balance of probability that that retrenchment was both substantively fair reason, substantively fair, and procedurally fair, that you followed the fair procedure. Now, you indicated earlier that it's not a checklist. Even though we follow the checklist, it's not a simple ticking off process. So the employer has to prove that he has fair reason and he's followed fair procedure before retrenching the employee.
Absolutely. Yeah. Okay.
Now, let's just briefly, the consultations, the question many people ask is how many consultations? I mean, you're going to be discussing all of this within a consultative context. And bear in mind, it is not a negotiation process. In other words, the parties don't necessarily have to come to an agreement at the end of the day. The employer reserves the right to retrench at the end of the day. So during these consultations, you may have one, you may have 2, 3, 4. It all depends on the circumstances at hand. There's no clearly defined number of consultations, but you most certainly need to make sure, as you correctly said, that both parties participate, both parties have their input, and that it is recorded with the view always, firstly, to avoid the retrenchments if possible. If you can't avoid, to minimize the number of retrenchments, and where the retrenchments are inevitable, to minimize or mitigate the adverse effects. So please, just going back to the written, your proof. You as the employer need to prove this, so make sure that your minutes are always recorded in writing, and as a matter of course, provide the employee with those minutes so there can be no dispute later on.
I think, as you say, it's the evidence, and it's just that real communication, which segues very nicely into this new slide. That, you know, I think in one of the other presentations, the facilitator, Jenny, mentioned communicate, communicate, communicate. And I want to echo that at this point. And you also mentioned that earlier, Leigh, about just in terms of the whole process, you know, giving the Section 189 notice isn't a guarantee that the person will get retrenched. It is a communication that things are dire and that you are having to look at alternatives. It's the start of a very serious conversation that might go on for quite some time, or might be quite quick, depending on how drastically things are actually moving. But it is a case, as with anything to do with employees and relationships, you cannot over-communicate. I really do believe that. The emotion in this slide really sums it up. You know, obviously, the retrenchment package is there as a way of ameliorating the financial impact. And it is legislated. There's no way of getting out of this. And I will talk to that just now, because some people do believe that they can just walk away from these obligations. It is legislated. You will have to pay out according to either your individual contract or a collective agreement or the Basic Conditions of Employment Act. But at the end of the day, what is really going to count here is the human toll. The human toll has 3 components. It is obviously the victim, the person who's being retrenched. It's the people around them who are suddenly left behind. And then there is you, the person having to actually do it. Probably one of the hardest things to do as a leader, as an employer, is to sit across from someone who's done nothing wrong. This is a no-fault dismissal. They've not done this. There was nothing that they could or should have done to change anything here. And yet here they are losing their job. And that is really hard, because you've actually got to now be the one to sit down and give that blow to somebody who has actually maybe served you loyally for a number of years. And how do you do that? And there is no easy answer. It really is. It is with heart. It is with compassion. So part and parcel of that is obviously making sure that you've at least followed the procedures, that you've at least done everything that you were supposed to do from the basics of the law. But that is the bare bones. Now it's how do you conduct yourself and how do you handle that scenario when you're actually talking to your employees? And empathy, realness, showing your own vulnerability, letting them see how much it is actually hurting you, are all ways of showing the leadership in a situation like this and tapping into their feelings. Be aware that this person is literally going to have to go home and face their family. They could be the main or only breadwinner in a family. And we all know the economic situation out there. It's a devastating blow. So you can't stop it. There's literally very little you can do about it except be empathetic. Be the person that they can turn to. Be the person that they can share their feelings with. And listen. Be kind. Be considerate in that kind of process. There's also the people who are left behind. You know, they've worked as a team for a number of years, and suddenly they're half their number, or a whole department has been retrenched because now everything you do is online, it's no longer a customer service desk, whatever it might be. There's a lot of fear out there. There's fear of the unknown. There's the am I next fear. None of those are good feelings. They're all terrible emotions for people to be dealing with, incredibly negative. And people are going to be looking to you as the leader for cues as to how to handle these emotions when they're actually having to go through it. So again, communicating, inviting people in, having an open online or an open door policy, whatever is the situation that applies to you, but being available to people and being able to talk it through and sharing that you also are scared and you're also waking up in the middle of the night. But this is where you can't wallow in it. You need to then come up with, but this is what we're putting into place. And this is why we've had to do this, but I didn't do this lightly. And this was the process we went through before we got to retrenchment. So people need to feel that you've got their back to a certain extent. There can be no guarantees. There are no guarantees that you might not have to do another set of retrenchments. Hopefully that wouldn't be the case. But the more frank and open and transparent you are with people, the more they will trust you, and they will trust that you are doing your best and that you are trying. And this is where, again, getting people, so this is not just about a communication with the employees who have been retrenched, but the employees who are staying, getting them involved in solution finding. How else can we build up this business? How else can we develop resilience? How else can we make sure this doesn't have to happen to anybody else? This terrible event that we're having to actually go through. People are innately creative. It's what we are as human beings. We are creative and we are resilient. So build on that, draw it into your discussions with your staff and let them feel that they are part and parcel of keeping this business alive, because they are as vested as you are. And then finally, there's you. You had to be the one leading. You had to carry all of this emotion. And this is your baby, this is your business, and it's in danger, and you are feeling threatened as a result. Obviously, there's financial worries. You may be bankrolling this individually, so that brings its own dynamics. Your own family issues are starting to come in. And eventually, you've got to be careful that you are not going to burn out yourself. So really, I can't emphasize enough how much you need to pull on your own network. Platforms like Simply Biz, and there are lots of others out there that are not just business, that are more leadership orientated, whatever, but use your network. Find out from other people how they are handling things. Check in with your staff, check in with your own emotions, and find out where you are in this emotional roller coaster that you're all going through. And understand when sometimes you just actually need to tap out. It is very important that you are able to stay in control of your emotions, because if you are seen to be going off at a handle and showing your emotions in negative ways to your staff, you will simply feed the monster. So you really need to build that strength and do whatever it is that you can to build your mental and your spiritual and your physical well-being during this particular process. And there's one I haven't mentioned, and that actually is the legacy that you're leaving. And this is your suppliers and your customers, because no business is an island. You cannot produce any product without suppliers and without customers. And they are all interconnected with your business. And it could be that you've had customers who've been working with you for 5 years, 10 years, 30 years even. In the case of some of the businesses that I've actually had experience with over the past few months rather, they've had to go through quite a process with their customers of explaining what they're doing, why they're doing it, what impact they're hoping to achieve by doing it. And they've had to allay the fears from customers that from suppliers that they will pay. They've had to allay fears with customers that they will still receive the same product, the same service. And those people are watching you quite carefully. They've interacted with your staff, and they're looking now to see how you behave as an individual, as a leader. They're looking at your integrity footprint at this point. And what is the legacy that you are going to leave behind? Because one day, COVID, lockdown, whatever it is that you're dealing with will be over, and people will remember how you've actually behaved in this way. So it is very important that you go above and beyond just what the law says. be creative, be helpful. And I've mentioned just a few things in the list there, helping your employees with writing CVs, giving them time off for interviews, sending them for counseling. There are a lot of places where they can go for free counseling. Providing training. No, you don't have to spend a fortune on putting together a massive training course. There is a lot of free training available online. Get them involved in shifting gears. It's an incredible opportunity that Simply Biz are providing here. It is free. Encourage employees that maybe that now's the time, that side hustle that Tani Maria in sales, who was always good at making cupcakes. Now's the time to encourage her in that business and actually guide her. So there are many ways that you can offer support to people that doesn't have to be financial, because we all know you're tapped out on that particular case. I did mention about the finances and the severance pay. It's very, very important to remember, as I say, it is legislated. You cannot get out of it. But what if you've run out of money? And this has happened to someone I know quite recently. They tried everything to avoid, and eventually they've gotten to the stage where there is not enough money, even with assets being sold in the business, to actually pay out the basic conditions minimum, which is 1 week for every year of service. At this case, all they can do is declare insolvency. Employees are preferred, but only below the preferred bonded creditors, and then preferred creditors after that. But they could be available to open to litigation in a civil suit. In this particular case, they are a partnership, so I've warned them that is a possibility. Those of you who are slightly separate in the sense of you're running an actual PTY limited, you have got limited liability, which makes it a bit easier, but it doesn't absolve you of your legal obligations, and that is the important thing to remember there. Leigh, I don't know if you have anything to add on that side.
No, that's quite right. And it's very unfortunate because although an employer doesn't or isn't absolved from its responsibilities, if there is no money, you then are, as you say, just one of the creditors. You may be preferred, but please, something that I have noticed is that people do give up. I understand you despairing, but don't. Participate as far as you can in the liquidation or insolvency procedures, because you may get something out at the end of the day. And also remember, you can still claim unemployment benefits for the retrenchment. Yes. Even if you were paid your TERS benefit, the TERS benefit is completely separate and distinct. So whilst it isn't the best that you may have wanted, it's better than nothing. So pursue it.
Thank you for that. Yes, very important point. And I think the not giving up from both sides, the not giving up as the employer if you're having to actually close your business, and I really hope that's not the case. But if that is the situation, this is just simply the end of a chapter. It is not the end of the book. And it is about taking that one step forward the next day, and how can you pull yourself out of it? I have been there before. I do know what I'm talking about. I've sadly gone through losing 2 businesses, and you can pull out. It is possible. And something like using the Shifting Gears program to actually help you go through that mental shift and actually start the process of maybe changing your business or putting a new business together is a really good way of starting to pull yourself out of that emotional mess that you might be feeling right now. So these are the templates that we have placed on Simply Biz website. They are largely based in the Geared Down booklet, but you can just go onto the website, go into the community section, and you will find these things available. We've got the Simply Biz has got some amazing articles, webinars, masterclasses, tools, checklists, you name it, all there to help a small business get there a little bit easier, a little bit quicker, and to give you just that little bit of a leg up, hopefully, so that your business can move forward. And this is what this was all about. We do hope that this retrenchment toolkit will help you get through a very tough time, but in a way that you and your employee retain your dignity and some hope.
Thanks, Jan. I know that we're concluding now, so just Firstly, I'd like to say thank you to Simply Biz for the opportunity given to me to be able to share some of the insights. And secondly, to encourage people, like you said, this is an amazing organization, firstly, and secondly, tool and assistance that everyone can use. Please, I encourage you to do it, because that despondency and despair can be dissipated or at least eased by following the program, or it's some form of assistance that you don't have to pay for. So use it. We've also, in line with that, we obviously are very proud to be associated with the Simply Biz, and we offer the first 3 Simply Biz members who contact us by email following this, that we will provide them with a 20-minute free virtual consultation, and simply obviously quote Simply Biz, shifting gears, and we'll be very happy to try and help you. So thank you very much once again, Jan, and thank you, Simply Biz.
Bye. Thank you.
Cheers. Bye.